Item number 1.
Yes. The
Lordship.
offer still stands.
Lordship, this offer was given way back in 2016, Your Lordship. So the ground reality is different now. There is no post vacant, Your Lordship.
So what are we to do? We'll hear it then.
I pray for sometime next week.
Yes.
Lordship.
Next week we'll hear it. Yes.
Lordship.
Yes.
Lordship.
Just take down. By order dated 6/8/2024, this court had queried as to whether the offer, as afforded earlier to the writ appellant, was still open for accommodation in some other post. Stop today, MSA Policy Counsel with so-and-so submits that the offer at that point of time was made in a different context, and the same does not survive consideration today. Stop. Accordingly, this is matter for hearing next week. Yeah.
Obliged, Lord.
Next week.
Obliged.
Any mention?
Yes.
Your Lordship, I beg to mention item 19, Your Lordship.
Item?
19 and 20, Your Lordship. May come after 2 weeks. I have to get the consent of the other side also.
Roderick Harbithai.
Lordship.
Yes.
No objection.
After?
After 2 weeks, Lordship. 19, 20, Lordship. Highly obliged.
Yes.
Your Lordship, I beg to mention item number 27. Your Lordship, may this matter come after 2 weeks?
You're for?
For the petitioner.
What's your name?
Spurgeon Arlen Khoi.
Your name?
Oh, my name is Orius Sinclair.
You have no objection?
No, Your Lordship.
After 3 weeks, yes. No urgency? No urgency in the case?
No.
Yes.
Not sure.
22 and 26.
22 has been adjourned repeatedly, Mr. Dr. Mazikra. Have you informed Dr. Saraf?
No, sir, we have not been informed as of yet.
Why? When? They're seeking after 2 weeks.
No, we have not been informed of the adjournment as
No,
of
do you
yet.
have any objection? They're seeking time now.
No objection.
Yes, 2 weeks.
26. 26.
We are in 22. The state is 22.
Where's the respondent 26? Yes, 2 weeks.
May I please, Your Lordship, I beg to mention item number 23, Your Lordship. I humbly pray let this matter be taken after 3 weeks, Your Lordship.
No objection.
No urgency. Then take 4 weeks. Okay, 4 weeks, yes.
Merciful Your Lordship. May I please, Your Lordship, I beg to mention item number 29.
29.
Let the matter be come up after 2 weeks.
Why?
Because the conducting counsel is out of station, Your
Who's
Honor.
going to Mr. Nath?
Yes, Your Honor.
My Lord, the council is also on sanction leave, my Lord. State council is also on sanction leave. No objection, my Lord.
Okay, 2 weeks, yes. Yes.
Lordship, 14 and 15, Lordship, item number. Taken consent, my Lord.
No objections. After 1 week.
There's no urgency.
No, Lordship. After 1 week. Lordship.
1 week.
Number 16 is also connected
Oh,
to
16.
14 and 15.
My Lord, 2 weeks, my Lord.
1 week, yes.
My Lord, kindly 2 weeks, my Lord.
They have objected to your 2 weeks.
Okay, my Lord. 1 week.
Yes.
Duly obliged.
Yes, make it quick. Any other mentions?
Daily list, item 13.
We'll cover that matter first. what is this?
Please, Your Lordship. I'm faced with a somewhat unusual predicament, my lords. I was facing a eviction proceedings under the Public Premises Act. I received notice, I participated in that. And my last appearance was sometime in April 2023. Thereafter, I stopped receiving any notice of the proceedings. This year on the 1st of
You
August.
took part initially?
Initially, my
engage a
lords.
counsel?
No, they appeared personally. So they were being called by issuance of notices. They would be told about the next dates by issuing notices either by registered post or through WhatsApp. So my last appearance was in April 2023. Thereafter, I stopped receiving any intimation of the further dates of the proceedings before the court of the estate officer. The last notice that I received was from the applicant who sought the eviction on the 1st of August 2024.
So how many dates went without you being present?
About 3 or 4 dates, my lord. I was not intimated about the dates. And a final order was passed on the 22nd of September 2023.
Final on 20, you were not aware about that?
I'm not aware.
You were sleeping, you're thinking that the matter had gone to sleep.
I had also made a prayer that this is a dispute concerning a boundary as well as a title dispute.
Forget about that.
My lord.
Now final orders were passed in September 23.
September 23.
You're not aware?
Not aware. Now, usually under the Act and the rules from thereunder, the final orders to be served in a prescribed manner. They have to serve it either in person or by registered post or by affixing a copy of the order in the... None of that was done. None of these steps were followed. So as per the final order, I was given about 15 days to vacate the property or they would apply force. But they did not go through with that particular order. On the
when
1st
was
of
the last
August,
order after you vacate? That order said they'll use force in 15 days?
That's the last order. Is it order of 22nd September 23, which is at page 66. At page 66.
This is dated?
The date of the order, my lord, is at page 69.
Second.
22nd September 2023.
This you received?
I did not receive. This is the final order of eviction.
And where's the then?
So kindly see right at the bottom, just below the date, it indicates order to be delivered to the addressee and one copy to be pasted at the conspicuous part of the premises in the presence of 2 witnesses. This was not done. I was neither served with a copy of this order by registered post, nor was this pasted in any part of the property. So I was therefore not aware of this. Thereafter, kindly see the next page at page 70. This is a communication dated 31st of July 2024. This is by the applicant, that is a defense estate officer, who had initially sought the eviction. He informed me by affixing a copy of this order of 22nd that so-and-so order had been passed. You did not comply with it. And so therefore...
Okay.
So your lordships will find at page 71 is what has been indicated. You are therefore requested to vacate the defense land comprising so-and-so in Shillong Cantonment is under encroachment illegal occupation by you within 15 days from the date of issue of this letter. In the event of refusal or failure to vacate the said premises within the stipulated time, you will be evicted from the said premises on 16/8/24 by the use of such force as may be necessary. This is what I received. Some officers from the cantonment came and served it to me. Now, immediately thereafter, I filed a statutory appeal before the court of the district judge on the 8th of August 2024. That is last Thursday. Now, due to the unavailability of the presiding officer, the matter could not be taken up. Therefore, the records were placed before the additional district judge on the 9th. The additional district judge was of the initial opinion that she did not have the jurisdiction to take up the matter because Section 9 clearly stipulated that the appeal has to be taken up by the district judge. We attempted to satisfy the court that that wasn't the case. We placed reliance on certain decisions. However, she came to the conclusion that she did not have jurisdiction, so she refused to take it up. And that order was communicated to us on the 12th, that is on Monday. The district judge rejoined duties on the 13th, that is yesterday. The records were placed before her. Now the problem is that because I was not certain whether the district judge would join or not, that's why I preferred a writ petition as well for some protection. Because 15th is a holiday, 16th I anticipate that very early in the morning they would come and carry out the eviction. And my entire case would be infructuous. Because my limited prayer is that till such time, because this is a time-barred appeal, my lords, I have filed an application under Section 9 as well as a stay application. Now by that time, my condemnation application is actually considered and disposed of, the stay may not be heard. The matter is again fixed today, and the window that is given to us is 2 to 3 o'clock because the district judge is also preoccupied with some other work, some administrative duties. We have a very limited time period within which our Section 5 application can be heard. Now, we anticipate we will be thrown out.
Madam, the matter was heard by the district judge yesterday, my lord. Matter is fixed today at 2:30. So can my friend pursue parallel remedies, my lord?
It's not a parallel remedy, my lord. Kindly see my prayer.
Absolutely parallel remedy, my lord.
Kindly see my prayer.
It's absolutely parallel remedy. On one hand, they are filing Section 9 appeal before the district judge. The matter was taken up yesterday. Matter is again fixed today, my lord, and simultaneously a prayer being made under 226, my lord, to stay. So my friend should decide whether he wants to pursue WPC or want to pursue the appeal, my lord. There cannot be parallel.
Let me explain this.
I thought my friend will come and withdraw this petition, my lord. He's asking for a stay, my lord.
The situation is very different. Because of the unavailability of the officer and because of the paucity of time, there is no possible way for me to pursue the remedy right now of appeal. It's not an efficacious
So you
remedy.
objected to the condemnation before the district judge.
My lord, the matter is fixed today.
No.
Nothing had happened yesterday.
I'll point out what has
In
happened.
fact, can I complete?
Yes.
So suppressing what transpired in the district judge's court yesterday. The district judge was clear opinion that today she'll pass an order of stay till Friday and giving us a time to. That was, of course, not recorded, but my friend was, I think, present in the court. So, once that transpires before the trial, before the appellate court, my lord, I was under very confirmed belief that my friend will withdraw.
The matter he passed effective order today.
No. Let me just clarify this, because what is being suggested that I'm suppressing some facts. The matter came up yesterday. Initially, the district judge was of the opinion that she would pass some sort of a protection order till Friday so that they could come back with instructions on my Section 5 application. They contended, and they were right in saying so, that till such time that the limitation application is decided, no stay can be passed. I conceded to that. And because of the paucity of time, I said I have preferred an application under 226. I informed the court very fairly. Now, this is my situation. All I'm praying for is some protection till such time the court can actually take up the matter.
Right also. Unless
My lord,
the delay is
will your lordship condone the
orders be
yes.
passed?
No, my lord, will your lordship condone the delay, my lord? What is the delay in filing the appeal?
There's no question of condoning delay in 226. The only questions are looking into the circumstances.
My only concern, my lord, that if
See,
he presses writ petition, my lord.
One thing, Dr. Rosika realized, matter of eviction, matter of demolition, always requires urgent attention of the court.
My lord, I fully agree to.
No matter how valid the order of demolition or eviction
my lord,
is,
I fully agree to. I can
hour,
only agree to that, my lord.
Usually, courts give protection till the matter, they've given a chance to breathe.
The matter is, my lord, I am not on that. My lord, my submission, your lordship, my lord, once the appeal is pending, appeal is fixed today at 2:30.
Are you opposing the condemnation?
Yes, fellows, they have opposed it.
And what the district just said that I'll for the time being pass an order today, giving us time to file reply. And while suspended,
they can't pass interim orders until the matter is admitted. That's the law.
And my lord will just see my prayer.
Once an appeal along with application for condonation is pending,
you won't
can in these circumstances the writ petition be filed, my lord?
You give undertaking, you won't take any. You will give undertaking that no action will be taken until the matter.
But there is no question of undertaking, my lord. The order has been passed since 1 year. Nothing has happened till now. I cannot undertake that no action will be taken in for another 1 month or 2 months or 6 months.
On technicalities and on law, fine. But then if the matter of eviction and demolition.
But they have to pursue one remedy, my lord. How can they pursue double remedy, my lord?
Because then
parallelly, my lord.
Then
what will happen at 2:30 before the district judge, my lord? How your lordship will stay the proceedings in appeal, my lord. Then your lordship pass and stay order. I think that's the only way. No.
Let's kindly see my
stay
prayer.
the proceedings before the district judge, my lord.
Kindly see my prayer. All I'm praying for is some protection till such time effective orders are passed. That's all. I'm not saying that lordship should completely stay the.
No, what the court's going to pass is just let them pass effective orders today itself.
Yes,
that's all.
No, my lord, what they had said yesterday, that in fact one of my learned seniors junior had appeared, colleague had appeared and said that they need to take instructions on the Section 5 application and file an objection. So they sought time till Friday, but Friday is the day when they will evict me. So the court said I will allow some sort of protection on your guarantee. But it was also pointed out that unless and until the Section 5 application is disposed of, no protection can be
take down.
That's all.
Yes,
But well, only one thing, whether 2:30 have to appear before a district judge or not, lordship.
Of course you have to appear. Enjoy the tea given by bar association and then go and appear. Yes. The petitioners before this court.
My prayer would be to stay the proceedings before the district judge, my lord. Your lordship will decide the matter, my lord.
Why decide the matter here? There's a statutory
Because
appeal.
once the district judge assured them that he'll pass as an interim order
When
today.
does statutory appeal, Dr. Mosca, doesn't matter. You have not. You wait for a few days. If you're not, since September, you have not taken any coercive steps. Yes, take down. The petitioner before this court assailing an order dated
22nd September.
22/9/2023 and consequent order dated 31/7/2024 to vacate the defence land where she is allegedly in occupation. Stop. The ground taken for preferring the instant writ application is that in the final proceedings that had culminated before the what court is this?
Court of Estate Officer.
Officer at Guwahati. The writ petitioner was never served with the final order dated 22nd September 2023 and only came to the knowledge thereof when she was served with the notice to vacate. Next paragraph, Mr. S. and Counsel for the petitioner submits that on receipt of the said order of vacation, the writ petition approached the district sessions judge under section
9
by way of a statutory appeal under section 9 of the Public Premises PP Act. But however, as the learned district judge was on leave, the matter couldn't be taken up. Stop. Today he submits that the matter was taken up. Today he submits the district judge has since joined, and on 13th.
Yesterday, 13th.
The matter was taken for consideration. But the same is fixed again today. Yes. He always submits that he further submits that though the matter will be taken up effectively by the district sessions judge, the only limited prayer he has this stage is that till such time the effective orders are passed by the district judge, he be given some protection.
Till the time matter is considered, my lord.
No,
Because
that's
whether the
submission.
district judge will.
That's a submission, Dr. Malika. That's not the order of the court. Oh no. Some protection be given. Stop. Some protection be given. Next paragraph. Dr. M. Mosika has strongly opposed the prayer and submits that the petitioner cannot pursue two parallel remedies on the same cause of action, and that as the matter is fixed today itself for consideration in the statutory appeal, no orders are called for at this stage from this court. He further submits that the final order had been passed since 22nd September 2023 until date. Nothing has happened, and as such, there's no likelihood of any coercive action being taken against the petitioner in the few days till the orders are passed by the learned district judge. Stop. Next paragraph. Having heard learned counsel of the parties and perused the materials on record. Stop. It is as submitted by the counsels as the matter is fixed today itself at 2:30.
It's 2 to 2:30. That's what's been informed.
For consideration by the district judge. This court at this stage will not pass any orders and leave it to the district sessions judge to pass effective orders.
Well, it's may just impress upon Lordship one thing.
Yes.
They had also prayed time to file a show cause till Friday. a matter is coming up today because the court wanted to see what lordships will do with this particular 226. Now, they will again pray, I'm pretty sure they'll pray for time to file a show cause.
That is all in apprehension.
No, well,
You
it's
make
also,
your submissions there.
then kindly keep this pending, will let it come on Friday. In case no orders are passed,
Yes.
that's all, my lord. At least I can agitate the issue here.
Yeah, this matter on Monday.
On Friday, my lords, because then Friday is the day when they propose to evict me from the property.
They won't
Friday.
do it.
It's actually indicated in that last order, that 16th.
Tired after independence celebrations.
I can't.
That was indicated in September 23rd order also.
Anyway,
Let's kindly have it on Friday, my lords.
okay, leave the matter on Friday for the orders.
Obliged.
You argue the matter today. What is there? And if the grounds are genuine, why you oppose the
In fact, the district judge has clearly said that today is.
We're not going to say what the district judge said or what didn't say.
Item number 2.
This court might say
I'm only on
anything.
parallel remedy, my lord.
Obliged, my lord.
Well, number 2, I am led by the Solicitor General, my lord, and the learned Solicitor General is requested for 12:30, my lord, because for 12:30. So it's an unusual prayer, my lord. If it's possible, Lords will take out the matter at 12:30, my lord.
12:30.
Lordships, I am appearing for the.
Or at 2, my lord.
Because 12:30.
Because some parted matter is going on in the Supreme Court, my lord, and the learned Solicitor General requested me, my lord, to make a prayer. My lord.
Not 11:30. See, the thing is that coming to the fact of the case, now you were given adequate time. The other 1537 candidates were given a retest because they were not given adequate time. Simple as that.
Lordships, if I may submit. Lordships, I'll take few minutes because.
Your Lordships, I'm appearing on behalf of NTA Learned. SG is leading me in this matter. I'm just requesting for a short passover. He'll be joining it in a moment.
Okay. Yes, after some time. Yes.
Oblige, Your Lordships.
Daily list item number 1.
May it please Your Lordship, if this matter can be taken up after some time, Your Lordship.
Why? Where's Mr. Sen?
It's on leg, Your Lordship.
What's the matter about today?
My lord, it's fixed for admission hearing.
No, why is fixed admission hearing?
My lord, we are challenging
Ready?
we are challenging the disciplinary proceeding against the petitioner, my lord, which is pending for last 18 years, my lord.
Yes, how many? 18 years?
18 years, my lord. He is the disciplinary.
Oh, yes, Mr. Sen said there's an order passed. Let's see what the order is. Let him come with instructions. List this matter to when? On Friday.
Item number 2.
Winless me. Yes.
Your Lordship, the respondents are yet to file the affidavit here.
My lord, state has filed I have not replied to our affidavit, my lord.
Who?
State has already filed our affidavit, my lord. We have not received any rejoinder, my lord. And so far as the private respondents, I'm not aware of that.
Well, enough, you all praying too much time. How much time you prayed? 9, 16, 19 and
12 and
9, 16 to 19. What about 10, 12 and 13?
I'm praying for respondent 10, 12, 13.
Won't allow any more time. How many times you prayed? Where's Mr. Sheikh?
He's on next. He's on.
Now, you see, on 14.3, Mr. Sheikh said that no affidavit on respondent 12 will be filed.
In fact, my lord, state will be able to cover up, but
Yes.
that is what Mr. Sheikh was
Now
on
you
the
won't file
impression.
affidavit on behalf number 12.
10, 12, 13 also.
Yes.
But then you said that Mr. Your senior or whatever, senior colleague has said that you don't need to file affidavit on behalf of respondent number 12.
We will file also.
No, but already it's recorded here. You have to ask for recall of the order then. I don't understand how people conducting the cases. How do you make a submission? Is it infructuous the matter?
My lord?
It's been infructuous. It's already infructuous.
That was our submission at the initial stage, right, my lord. The petitioners were not ready to accept that, so we had filed our counter subsequently.
Without the counter can be disposed of.
We'll file a rejoinder today.
Without the counter, is it possible to dispose of?
It can be, my lord, as far
Without
as we are
filing, no
concerned.
need to file. Just be happy. Yes. Take down Ms. MS Adatta for 9 to 16 and 19 praise for the 1 week's time to file affidavit. Mr. So-and-so, Honorable Vice Ms. Asli Sheikh, praise for time, also similarly praise for time. It is noted that by order dated
My lord, I am for NCT, my lord.
yes, 1 second. By order dated.
My lord.
By order dated. Order dated 15/7/2024. Oh no, sorry. By order dated. Where is that? What order just now? I won't file affidavit. Good job. 1 second. It's very strange. Just now I read it. Just not read that order. Whereby. Oh yes. Hold on, no? On or by order dated 14/3/2024, this has been recorded. The submissions of Mr. S.E. Sheikh have been recorded, whereby he has submitted that no affidavit will be necessary on behalf of number 12, and that alliance will be placed in affidavit of state respondents. However, prayers made today again to file joint affidavit along with the respondents number
10, say 10, 12, and 13.
number 10, 12, 13. Stop. You clarify the matter. Yes. No order of the 13. Stop. This is the matter for further orders of after 1 week, after 2 weeks for rejoinder by the petitioner to the affidavit by the state respondents and for further orders. Mr. Sheikh was Mr. Sheikh. You call him, otherwise how he's made a submission? You're not filed for recall. We don't accept the respond number 12. Otherwise, understood? I don't think understood.
Item number
Yes.
three.
Right.
Yes.
May I please, Lord? Your Lordship, we have taken the steps on 25th of July to
Yes.
register ID.
We took when the steps?
25th of July, Your Lordship.
Officer indicates that service of notice not complete on the sole respondent stuff just after 2 weeks of wait service report.
Your Lordship.
Item number 4.
My lord, the respondents, my lord, I appear for 5, 6, and 7 VEC. I'll be filing my affidavit in course of the day, my lord.
1 to 4.
I'll be filing the copy of the Your Lordship.
My lord, if my lord permits, the remaining respondent, that is the VMC members, my lord, that is 8 to 37. Lordship, I have been instructed to represent them, my lord. If Lordship permits, I'll file my authority, my lord.
8 to 37.
Yes, my lord.
MS Koni, MS Ailingma on behalf of 1 to 4. And MS Al Koni 5 to 7 submits that the after we file the court of the day is further submitted that MS Al Koni will be appearing on behalf of the remaining respondents 5 to 37.
8 to 37.
8 to 37. Stop. And this is matter after notified affidavit on behalf
My
of
lord
other
will be
people.
filing. My lord,
She
I'll be
praised-
filing today for 5 to 6.
She praised,
6,
yes,
7.
she also praised that she will allow to file affidavit on behalf of the other respondents in a period of 2 weeks. This is thereafter.
Item number 5.
Lordship, I'm filing the affidavit today, Lordship. Rejoin the affidavit.
Lordship, we have received a copy. Fairly simple matter, my lord. If this matter can be disposed at the order stage itself, maybe next week.
Next week, Lordship.
You've seen the other cases where this has been condoned.
My lord.
This little kind of discrepancy.
My lord, there are some other cases where it's not been condoned, my lord.
See, sometimes these oil companies, they just, because they are saddled with authority, they abuse of power also. Can be corrected, yes.
Next week, Lordship.
Next week.
Oblige.
Lordship, the MLA was allowed 1 week and for the joinder. Yes,
Lordship, the interim order may be extended.
interim order until further orders, yes.
Item number 6.
May I please, Your Lordship? Your Lordship, I am paid 2 weeks' time, Your Lordship, to file the affidavit.
2 days time.
2 weeks' time, Your Lordship.
GHEDC.
Yes, Your Lordship.
So Nokma matter. You file yours.
Similar period, Lordship. This is second time.
No objection.
No objection, my lord.
Further 2 weeks as prayed not to respond file affidavit. This thereafter and so.
Your Lordship.
Item number 7.
Your Lordship, I have already sent the affidavit service for signatures. I require a few days' time, Your Lordship, to file the same.
Yes. What signatures?
For the affidavit service, Your Lordship. I just require a few
You've
days.
served?
Yes, Lordship.
Mr. Lalsong Guya, please was allowed further 1 week's time to file affidavit indicating service.
My lord, I require some time for the counsel.
Ms. Kimutaji, on behalf of the respondent, please funds allowed for the 2 weeks time to file affidavit. Yes.
Item number 8.
We're still waiting for the affidavit, Your Lordship.
My lord, I just humbly play because I'm for responding 2 to 5. We're waiting for some vital report.
Some?
Important report, vigilance
What report?
That is a vigilance because what had happened at the first instance when the writ was filed in the year 2016, writ WBC 20 of 16, subsequently it was withdrawn. The claim of the petitioner is that they say that they were oblivious of the criminal proceeding against them. They were oblivious and subsequently it was withdrawn. A fresh writ has been filed. So now there are certain documents that is to be supported.
You haven't filed the affidavits yet?
No, my lord.
So how much time do you need, Mr.?
We need another 2 weeks' time.
No effort from your side. Yes, Mr. A. Khan, for respondents 2 to 5, please funds out for a 2 weeks time for affidavit. This is thereafter. Yes.
Obliged.
Item number 9.
Please, Lordship. Lordship, this matter I pray for further time to file the affidavit, Lordship. 2 weeks' time, Lordship.
The fresh matter?
Yes, this is the, I have taken time on 2 dates. This is the third time, Lordship.
Why? You've got instructions or not?
Yes, I've got, I'll
Then?
file it. In 2 weeks, I'll file, Lordship.
Not 2 weeks. Why you got instructions? Why not filing the affidavit? When do you receive instructions?
Lordship, because this matter I had sought some clarification from the department. So That's why,
Further
Lordship.
1 week's time as per allowed for the affidavit. Yes.
Your Lordship, from our side, we need to file the service affidavit. By the way, because of the Independence Day, all the teachers are still.
For the other respondents?
Yeah, for the other respondents.
3 to 5 is Mr. Kharmi. What about number 1 and 2?
1 and 2 is for.
They're not been served.
NIOS. No, it's already served. But
Respondent 1 and 2.
1 and 2.
But
we have already received a report also from the post office, but just to file the.
Yes, let's place for out for the 1 week's time. There's a P. Shati also praised that he will have to file affidavit indicating service respondent number 1. Prayers allowed.
1 and 2, they are respondent, important respondent.
Prayers allowed 1 and 2. Yes, after 1 week, yes.
Number 10.
Lordship, in this matter also, Lordship, I have same prayer.
Where's the petitioner?
Petitioner is MF Qureshi.
Your Lordship. So yes, as prayed for the 2 weeks' time is allowed.
Obliged, Lordship.
So respond to file. You file affidavit? No.
I'll be filing, Your Lordship.
Item 11.
11.
Lordship, I'm praying for further 3 weeks' time to file affidavit in this matter.
What's the matter about?
These are those connected matters regarding benefits of warrant officer, Lordship. It's fully covered, Lordship. By
Lordship, I'm praying for further 3 weeks' time, Lordship.
3 weeks' time, what will happen to the other 1252?
So these are connected matters.
Connected,
11 and
Lordship.
12. Similar prayer.
We give 2 weeks, enough. 2 weeks for the time as prayed. Never enough for us.
Highly obliged.
Highly obliged, Lordship.
12.
12
Connected
is
matters, Lordship.
same matter.
Mm. 17. Hearing 17.
This, Your Lordship, was heard in part also, Your Lordship, and
Your Lordship, the conducting counsel is in other courts.
Who's conducting counsel?
Kechi Gautam.
What's the matter about?
It's a VRS, Your Lordship.
VRS?
VRS, Your Lordship. They were given as per the third pay commission, but they were not satisfied with it, and so they have come before this court for the balance
I
amount.
don't remember hearing this matter.
Your Lordship had heard us. This is regarding the MEDCL, Your Lordship, Meghalaya Electronic Development Corporation.
Oh, yes.
Please, Your Lordship. Your Lordship, the conducting counsel is on legs at the moment. Can it please wait that this matter come at the end of the vote?
But I don't know if the state is there or not. I am for the MEDCL.
State is there.
Yes, no.
1, 2,
Shilla,
3, 4.
The state council is not
Who's
here.
from IDC? You're from IDC.
I am for MIDC and the MEDCL, Your Lordship. The holding company, oh yeah, she's come.
Sorry, Lordship, I was on my legs here.
Yes. Who's the most effective respondent here?
The state.
The state. Let him come then.
Because we're depending on the state for financials, Your Lordship.
After some time, let him come.
If it can come, I didn't do my finance.
18.
May it please, Your Lordship. Lordship, I'm appearing on behalf of respondent number 428, Your Lordship.
You ready?
Lordship, I'm praying for weeks
What's
competition.
the matter? Pata?
No, this is what happened. They have filed
Ready
a
with the
petition
matter?
Lordship, I'm on limited instruction, Your Lordship.
without filing the separate continuation of delay, Lordship. And number 2, the petitioner here is nobody, is not even a NOCMA also. Prior to passing of the EM has passed an order.
The petitioner here is not a NOCMA?
Yes.
Where?
This is NOCMA of Daribokri.
No, the petitioner is not.
Petitioner also NOCMA. I'm sorry, Lordship. That respondent, Lordship. Yes.
You file affidavit? You file affidavit? You filed it?
Yeah, filed, Your Lordship.
Why so many lawyers from your office not ready? Why not ready?
Lordship, I tender my sincere apology, Lordship. Lordship, I tender my apology, Lordship.
Can't hear.
I tender my apology, Lordship.
No, tendering apology wouldn't help. It's for your own good, you know, that you prepare
Yes,
cases. If your senior doesn't prepare, you read the file.
Next time here.
Why your senior doesn't allow you to look at the files?
Yeah, Your Lordship.
Give a
In
lock
fact,
and key.
briefing counsel is Mr. S. Mr. S. Chanda is looking after the brief, Your Lordship.
Doesn't matter, Mr. Chanda locks the file.
No, Your Lordship.
So if we are manning the courts, and if there are certain cases we assign, you look at it, you argue it. If adverse orders are coming, you won't pass orders, but you should take the opportunity to, to argue.
Hold on, Your Lordship.
Because no other courts will allow you. You argue. Why? Out here we have less matters. So you take the opportunity. How do you hone your skills as an advocate? You study the matter, you try to understand it, and you argue it. There was a point of just taking time, then we'll hear you. No matter is too hard, nothing. It's just you master the facts, that's enough.
He's expert, my lord, actually.
How do you know he's expert?
I have seen in the lower court.
Achha? So he's just pretending out here?
He's pretending.
Yeah.
He's
How
very
do
well
you say
versed.
about you?
He's arguing a lot of
So-
cases
so-
in the lower court, I've seen.
Okay, so
Only here he's not arguing. I don't know the reason why.
then you won't be spared.
But in the lower court, he's very much expert.
Achha?
He's demolishing us also.
Defeating you also?
Yes. In the lower court, he will trust us.
So you're Dr. Jekyll, Mr. Hyde. Before the low court, a tiger. Out here become a kitten. Then you argue. Next time you argue. Next time you start out, won't allow adjournment, like when the matter has been called out. So you should argue it. So I've heard certificate given by Mr. P.T. Sama.
Yes, it's true also.
It's true.
Yes, Lordship.
So you have no excuse next time. He is the leading member of the bar, maximum number of filings every week. Yes, on the request of Mr. Kiram, this is matter after 1 week. Mr. Kiram further undertakes to argue the matter on the next date.
Item 21.
Much less, Lordship.
Yes, Your Lordship.
Where are those cuttings?
Lordship.
No, the newspaper, the physical is where he said 20 dates have been taken.
Lordship. And the pen drive is also here, my lord.
We'll drop contempt, Mr. Sangma.
Your Lordship, I
Because
think
at
will
that
not.
it's interfering with the. It's interfering with the.
But different paper, different.
No, it's interfering with the.
contents
But
there,
is it a
Your
fact? He
Lordship.
went and gave interview and all.
I asked him, and he was telling me that he gave only one word, that
No.
I have gone to the court to seek justice. And those are, he was probably provoked by the newspaper and not.
Why did he talk newspaper in the first place?
It was in the meeting.
Why did he talk? Why did he talk in the meeting? Do you know that he's interfering with the cause of Amsterdam justice?
Because he is a young,
No.
Your Lordship, and he does not know the procedure of the court. That is why I pray on his behalf, not
You can't
to
pray
take
on
any
behalf.
further-
You have to appear personally. We're drawing contempt. We have to draw contempt. We can't let this thing happen. You can't go to the papers and see everything.
Just,
see what is
forgive
in here.
him, Your Lordship.
He said that since petition was filed before the High Court on April, and the court has already held more than 20 hearings. I wanted to file a petition as soon as the
Just
government
give
issued
a
one,
warning,
but it's not
Your
my
Lordship.
support. Now officers back me since we're fighting for the same cause. He informed some memorandum, Chief Minister issued, prescribed so and so. He urged, who is he?
He is one of the member of those.
Why did he speak to the? Why did he speak to the media?
I don't know. On that day he might have been provoked by the newspaper, Your Lordship. But different newspaper, it is speaking different in the other
No,
in Kasi
the other one
newspaper
also,
and
this
thing.
other one. Shall know the petition was filed so and so. Despite numerous hearings, the issue remains unresolved. Here in this
In Meghalaya time differently, sir. They didn't speak about this.
he also informed
And
the forum was challenged.
no sign
Where's the
remark.
forum? Where's the forum challenged the SOP
No,
for the High Court?
That is wrong, Your
Then?
Lordship. It is wrong.
Meghalaya Times, Guardian.
since he does not know the procedure of the court, I think I pray before your lordship.
You can't pray, you have to pray in writing.
Yeah, I will file
you let
affidavit.
just take down.
I will file affidavit
no,
of
yeah,
apology, your lordship.
the paper news clippings of press reports with regard to conduct of writ petitioner in criticizing the courts and speaking to media in a matter which is under consideration has been submitted by the learned senior government advocate. The writ petitioner is directed to be present personally in court on 21st August 2024 at 10:30 a.m. Let him come personally.
Yes, Lord. Highly obliged, your lordship.
Otherwise, you can't do this.
Item 24.
My lord, the
Can't be over smart, yes?
the pen drive is with regard to virtual news, lordship.
Yes,
The pen drive also.
Where's the pen drive?
It's for the court, lordship.
Yes.
Much obliged, lordship.
Mr. Sangmal, very unfortunate.
As it is said, wrong, unfortunate, your lordship. It happened.
You should advise your client.
But on that day might be provoked or something.
Bravo, he felt, where did he go for the meeting?
I do not know that one.
Yes.
Obliged, lordship.
Your lordship, kindly grant me few weeks time, since you're still doing some research on
Yes.
it. Can you please grant me some time?
Who's the arguing counsel?
Mr. Argurum.
You read the file. Are you familiar with the facts of the case?
Yes,
Very
sir.
good, then start. Yes, what's the matter about?
It's about the pension matter.
Yes?
Retirement benefits, your lordship.
Yes, let her argue. Yes. Pension benefits.
Yes, yes.
Yes.
Lordship, I'm not ready for the argument.
No, you argue, doesn't matter. Now what is your prayer? How are you entitled? Read it. Yes. Yes. Don't be afraid. Argue.
Your lordship, I pray for 2 weeks time.
2 weeks time to do what?
We're still doing some
What is
research.
your name? What is your name?
Chetri, Anisha Chetri.
You argue this matter next date. Okay? You'll argue it. We'll fix it next week. You prepare it. Yes, MS Chetri today has sought time on behalf of a senior who stated to be unavailable staff. She, however, has undertaken on being queried by the court. On being queried by the court, she has undertaken to argue this matter the next date. Yes. List on? When? List
After
up.
2 weeks.
Not 2 weeks. Why 2 weeks? How much time do you need to prepare? Small matter. You argue the matter, okay? This matter after 1 week, it is on the 27th. All right? Yes. You argued on that day, not Mr. Guru.
Item
When Guru
25.
appears, we won't record the submissions.
May it please,
Yes.
Your Lordship. Your Lordship, I pray if this matter could be taken at the end of the board, Your Lordship.
How many end of the board? Or will coming end of the board?
My lord,
The
may,
conducting counsel is in his legs, Your Lordship.
Isn't this post?
No, Your Lordship, is near the court.
my lord, may kindly have this matter on any other date, my lord,
We are ready with the matter, Your Lordship, today.
because there are some programs also, my lord, so it may not be possible.
On the prayer of the party, this matter up to 1 week.
Much.
26.
Okay, sir.
Frame for some time, my lord. After 2 weeks.
So, yes, sir.
It's been in the morning, you're not here.
So, oh, I'm so sorry, Your Lordship. I was in legs.
After 2 weeks.
Oblige, Your Lordship.
CBI against a sweeper.
My lord, not on that account, my lord. Here what happened, my lord, the law provides that 50% minimum punishment has to be given. My lord. Here only 1 day till the rising of the court. That was the sentence awarded, my lord.
But Lordship, one submission. Lordship, here the suggestion was given by to both the parties by the learned judge, and also the special public prosecutor was present, and he agreed to that, and he has signed also. So question is on that also, Your Lordship.
Plea bargaining, the CRPC provides that.
28.
Oblige, Lordship.
Please, Your Lordship. My Lord, I am obliged that this court has provided me the case law, my Lord, at the last date. And after going through the judgment, my humble submission is that, my Lord, the petitioner is confining its argument only on Annexure A, my Lord. Annexure A is the...
Where's your opponent?
My Lord, I am appealing for the verdict.
What's Annexure A?
Annexure A is the affidavit filed in opposition, my Lord, by the state, my Lord.
Of the reply, issue 1.
Yes, my Lord.
Page 11.
My Lord, I'm
What's
confining...
your case about? Sorry. What is
my Lord, the writ petition is... The challenge in the writ petition is the selection of respondent number 2 for the post of counsellor, my Lord.
Okay. You didn't qualify. You got 87.4 marks.
Yes, my Lord.
And the one who qualified got 93.2.
Yes, my Lord.
So what is the ground of challenge?
My Lord, my ground of challenge is that, my Lord, which authority has formed a departmental selection committee, my Lord, that has not been disclosed, my Lord. And, my Lord, this departmental selection committee is constituted by whom, my Lord? And the committee, after the interview, has given the report to which appointing authority, my Lord? That is silent, my Lord, in the affidavit filed by the state, my Lord.
Why would that be material?
My Lord, kindly come to annexure number 1, my Lord.
Of your case?
No, of the one which is filed by the state, my Lord.
Annexure A, you mean?
Yes, my Lord.
Annexure 1, okay.
Yes, my Lord. Here the chairman is also, my Lord, is a part of the departmental selection committee, my Lord.
The chairman is the DC here, and I would explain if there's a requirement to explain this, but this was not the ground for challenge in the writ petition. In the writ petition, they claimed their right to challenge it owing to the fact that they had got the second highest marks in the written examination. They said since they had got second highest marks in the written examination and the person who got the highest marks did not appear for the interview, therefore they had a right for selection. The fact that they only appeared for the interview apparently gave them a right for selection is what was the basis in the writ petition. No matter that definitely cannot be the basis because the selection is decided upon written examination and interview. They could have made a representation.
Who's appearing for selected candidate? No one appeared?
No one appeared, my Lord.
No one.
1 second. Oh, that's all. You said that since you came You came second written test.
Yes,
The person who got first person didn't appear for the interview, and so after interview you should have got the job.
My lord, my humble submission is that, my lord.
Yes.
The state
How?
did.
Yes. How will you sustain your case?
Yes, my lord. The state did not say anything about the interview in the affidavit, my lord, which was filed by them. Not if the appointment which has to be given, my lord, let it be in fairness, my lord.
In fairness, no, you appeared for interview.
Yes, my lord.
You appeared for interview, correct?
Yes, my lord.
Then?
But my lord, here, my lord, I have also mentioned, my lord, in para number 4 of my
See,
rejoinder,
you,
my lord.
in the this is your own case. See, our sympathies are with you, but it's difficult. See, 22.4 is one interview. That other lady got 30.2, correct?
Yes, my lord.
And though in the written,
Yes.
you got 65.
Yes,
and she got
my
60. Only difference of 2 marks.
My lord, but here,
You're a
my
Bachelor of Social Work.
yes, my
You
lord.
have a degree in
Psychology, my lord. MSc Clinical Psychology, my lord. But my lord, here, the affidavit filed by the state, my lord, that it has not been disclosed, my lord, which authority has formed a departmental selection committee. That has not been mentioned, my lord. And
You're
Annexure
appearing
A
in
has...
person, that means. You're appearing in person.
No, I'm not appearing in person, my lord.
Then-
I'm appearing for the petitioner, my lord.
Who's the petitioner?
Sophia no say, my lord.
It's not you.
No.
Oh, sorry. I thought, but you are,
No.
what's your name?
My name is Sylvia no say, my lord.
Oh, Sylvia. Okay, sorry, mistake. I thought that you're the one who, yes, okay.
My lord, my lord, when the Annexure A has been prepared, signed by the departmental selection committee, has not been mentioned, my lord.
Why is it important to mention that?
My lord, there is no date when it was prepared
That
and
doesn't
everything.
matter.
My lord, and under
It's been
which
signed
rule
by
and
all the members. It's been signed by the chairperson of the Child Welfare Committee.
But who
It's
has-
been signed by the District Child Protection Officer. It's been signed by the Member Secretary of the District Social Welfare Office. It's been signed by a member of the JJB. What more is there? It's constituted by people who are in the know of how to. And the thing is that, see, you can't turn around and where's the judgment I gave you last time to see?
Yes, my lord, I have read the judgment.
What does the
my
judgment
lord.
say?
My lord, the judgment says that I cannot, once I participate
Yes.
in the thing, I cannot challenge, my lord. But my lord, my humble submission is that,
There has to be ground for challenge. You have not made out any ground.
my lord, my ground is that, my lord, if the interview has to be held, my lord, it has to be held with all fairness, my lord. And
How do you know it's not held with fairness?
my lord, how can the chairman be participate in the process of departmental selection committee?
was the
Who is
DC, my lord,
my lord?
with
Let
the
me submit,
IC.
my lord. Let me submit. Who, my lord, who has formed this? Constituted this committee by whom, my lord, that has not been disclosed, my lord. The committee, after the interview, has given the report to which appointing authority. That also has not been disclosed, my lord. My lord, in all fairness, my lord, please give me the chance, my lord.
How will you give the chance?
My lord, if you see, my lord, the chairman, my lord, to Kelba Mary, my lord, has awarded the marks of 46, my lord.
No. Where 46? In
My
the
lord,
interview?
Annexure A.
No.
Annexure, what? my lord?
Kelba Mary has got only 30.2 in the interview. You got 22.4. So the same thing, this number, this urbanity, Marbanyang was the same thing.
But my lord, who has approved this list? This is also not disclosed, my lord.
That's not, they don't have to do it.
Well, this is under ICPS scheme, which is a central government scheme, and they themselves say that this would constitute the interview board.
We'll pass orders.
They have followed.
There's no case, sorry. They have to, usually challenge has to be on cogent grounds, you know. It has to be patent illegality, special selection process. Now you've taken part and the interview board, we're not going to sit on top of a expert committee that's decided. That's all. Improper selection, nothing appears there.
My lord, kindly note my submissions and on the
We'll
basis
pass
that...
Okay, I pass an open court. Yes. Right. The writ petitioner. Sorry. The brief facts are that the petitioner had applied for the post of consular pursuant to an advertisement issued by the respondent number 1 dated 16 April 2023. And in the written exam, the second highest marks. So, in case of the petitioners that having secured the second highest marks, however, after the interview, appointment was afforded to the respondent number 2, who had scored lower than her in the written examination. MS Tong said, learned counsel for the petitioner has vehemently argued that. What is the argument you said?
My lord, my argument is that, my lord, that which appointing authority has formed the departmental
I'm
proceeding?
going to argue that it is not clear as to what authority had constituted the interview board which conducted interview and granted higher marks to respondent number 2.
And my second submission